From the Subaru of Gwinnett studio, this is Injury Insider with Derek Hayes. Injured in Georgia? Make the right call to the law office of Derek M. Hayes at 404-777-HURT. Injury Insider is presented by Status Home Design, your one-stop shop for all your home and gift needs.
Hello and welcome to Injury Insider with Derek Hayes on Business RadioX. We are broadcasting live from the Subaru of Gwinnett studio in the Sonesta Gwinnett Place Atlanta Hotel. This show will answer legal questions and debunk personal injury myths with insight and expertise. For nearly 25 years, Derek Hayes has exclusively represented injured parties in Georgia. Now he'd like to put that knowledge to work for you. My name is Lita Brooks, and it's my pleasure to introduce the star of the show, Derek Hayes. Good afternoon.
Good afternoon. I'm looking forward to this show. This is a fun one.
This is a really good show. It was definitely my favorite topic from all the past shows that you've done. Before we begin, a quick reminder that Injury Insider is brought to you by Status Home Design, your one-stop shop for all your home and gift needs, and by the law office of Derek M. Hayes. Injured in Georgia? Make the right call to the law office of Derek M. Hayes at 404-777-HURT.
All right, what I was going to say is sometimes just talking about the law can be very, very, very boring.
Not on your show.
But we try and bring some fun and entertainment to it. But this is by far a lot more entertaining, a lot more fun than just talking about slip and fall and dog bite cases and car wreck claims and all those wonderful topics we've covered in past shows.
So last year, or in the past, that since we've been taping, was it one or two shows? Was this condensed to one?
It was one show that did this, and then the second show covered the winner, so to speak.
So we did a show on the 20 most outrageous lawsuits.
Yeah, crazy lawsuits.
Crazy lawsuits.
Right.
And it was such a big hit. We ran a contest where people submitted their answers to you via social media and on your website. And we would poll, and even while we were waiting on the results, because there's a gap of a week or two between the show and then the results show, we couldn't stop talking about it. Oh, you're not going to believe this. You're not going to believe this. So we polled everybody we knew, and we had this big collective results show of all these people that had submitted. That was so fun. And I know we'll still go to parties and talk about some of the crazy lawsuits.
And people can't believe, because they're so crazy, the fact that someone sued over certain issues. Go back and listen to that one because it is very entertaining. This will be the second version of that. And I've titled this one, Lowering the Bar, 20 More of the Craziest Lawsuits.
So you found 20 more.
Oh, yeah. Well, there are plenty more, but I limited it to 20 more. That's a good way to put it.
Okay.
That's a real good way to put it.
Well, it's going to be fun. Hang tight with us. We have one announcement that we want to make before we jump into today's show. Derek, this is your show. Take it away.
Well, Lita is not only the host of my show, but she and I have been together as a couple now for a little over 3 years. And on Saturday night, this is now Wednesday. We're taping on a Wednesday. Saturday night, just this last weekend, I got down on a knee and I proposed marriage, and she accepted. And so now we are officially engaged.
We're engaged.
She is truly my significant other.
He keeps saying that too every time I call. Hello.
How's my wife to be?
How's my fiance? And I just let it roll.
Yes,
anyway, it's very sweet, and the moment was beautiful and special. And I had no idea. I tell everyone I hoped, but I didn't know, because a lot of holidays have come and gone in the last 3 years. But the timing wasn't right, and it all happened just the way it was supposed to on Saturday night.
Absolutely. And I'm going to plug your show, Status Life with Lita, Leta. Another incredible podcast. I encourage you to go back and listen to the most recent episode. We actually discussed the engagement, how it went down.
We did an entire show, and we didn't even mean to, but my show is storytelling, and it's a lifestyle podcast. Derek is the host of my show, as I am the host of his, and that is because there's no one better to sit across the table from each other on our shows. And so instead of going into all that here on the legal podcast and having two shows about our engagement, we're just encouraging you all to go to Status Life with Lita. Get the story. It is fabulous. It's beautiful. And we talked a lot in some previous shows of mine I'm digressing here, but stay with me. We did a whole series on blending families and the do's and don'ts. Also a great series, but a lot of that really came to head on Saturday night, and we go into that in the show.
Yes.
So that was very important for us and for all 4 of our children.
That's right. That's right. So definitely go back and listen to that, and also go back and listen to many of the other episodes of Status Life with Lisa.
Sure.
You'll be very entertained.
I'm very entertaining.
Yes, you are. That's why you're hosting my show. So, but today on this podcast,
the fun one. All right.
Before we get into this, I want to say a couple of things. Number one, when I could, I listed the year, and we'll discuss the year that this happened, or when the lawsuit was filed, where it occurred, what state, or if it was a different country. There were some where I couldn't find specific outcomes, whether there was a dismissal of a lawsuit, or a lawsuit was ever actually pursued, or whether or not a judge threw it out, or if there was a verdict. So where I could, I kind of put the outcome there. So some of these you'll hear beginning all the way to the end. Others, they really didn't follow up as to what happened to it. But enjoy. These are really, really crazy. And when we're done, I want everybody to send in their vote for give me the top 3, number 1, number 2, and number 3. I had votes from all over the country with the last one. It was great. And we even voted here in the studio. Everybody get to say which one they thought was the craziest. And we're going to do that today as well. We're going to get votes from everybody here in the studio, because I'm curious to hear what your answers are. I already know, because I've prepared the show, what my favorite crazy lawsuits are.
And I haven't seen these yet.
No, you haven't. That's it.
I'm going to be hearing these and going through these just with our listeners. So what I was going to say, go back to the last show. What was the number 1 from the last 20?
Again, we did 20, and they were did the top 3. So we'll go with number 3, and the drum roll for number 3. It was a gentleman who sued an armament company that makes ammunition. He had gone on a safari hunt over in Africa, and a lion charged him, and he shot, and he hit the lion. The lion didn't die, and the lion attacked him and mauled him pretty badly. So the man sued the armament company because he claimed the bullet wasn't effective enough to kill the lion. Even though the shot did hit the lion, it hit the lion in the shoulder. Well, unfortunately, a shoulder shot in a charging lion is not going to do anything to take them down. So the man was mauled. So instead of taking responsibility for the fact he apparently is not a great shot, he sued the armament company. And it was thrown out. There was no recovery in his favor. But that was number 3. Number 2 was a man who decided that after visiting SeaWorld with the family and going to the gift shop and getting a plush a Shamu killer whale plush toy, a stuffed animal, he thought what wonderful thing it would be to hop in the tank and swim with a killer whale. This man was 39 years old, so he stayed after hours one night, hid, and then when the park closed, he came out of his hiding place, and he decided to jump in the tank with the killer whale. Well, when he jumped in the tank with a whale, the killer whale does what a killer whale does. It killed him. So the family sued SeaWorld, claiming that the fact that they sold stuffed animals in the gift shop and did these shows, it made people think that killer whales were actually cuddly and sweet.
That the stuffed animals were made to look friendly and
cuddly
cuddly.
And right, yes.
And oh my gosh.
And so the man was killed by the killer whale. That was number 2. Now,
for jumping in the tank.
Right. The number 1 craziest lawsuit, I'm sure you probably remember this.
This is a doozy. Oh, I'll never forget this.
It was a gentleman who sued his wife because their children were ugly. He sued his wife because they had
it was an ugly baby.
Ugly baby, right?
Yes.
And the premise behind this was that and it was in Japan or China somewhere, he sued his wife because apparently before he met her, she had had lots and lots and lots of plastic surgery. So the real wife no longer looked like she did prior to him meeting her. In fact, she apparently looked very attractive, and attractive enough he thought he would marry her, and he did. But apparently the babies came out looking like pre-plastic surgery version of her. So he sued his wife because the baby was ugly, the babies were ugly, and he actually won. The court gave him money.
I forgot that
part. A jury
part.
gave him money because of the false pretenses of marrying him without telling him she had previously had plastic surgery. So to think dad thinks his own kids are ugly enough, he's going to sue mom for producing ugly babies. So that was the number 1 craziest lawsuit.
Yeah, and it very well should be. So
Oh yeah.
we have a lot to cover, so we're going to jump into... Now, these are in no particular order.
No
so
order,
I'm
right.
going to number these only because if you're listening and you'd like to vote and you're driving or something, you can just remember the number, okay?
Yeah,
and you
that
can
works.
submit the number. So
that
again,
may be the title too.
Right, of course. But if you're, on a treadmill or walking around a park, wherever you listen to podcasts, all you have to do is try to remember the number and any part of the title, and that will be sufficient enough for your vote.
Yes.
Okay. All right. So this is number 1 on our list today, and Derek has called this "Uber Ruined My Marriage." This took place in 2017.
Yes, and the irony, I guess we just talked about getting engaged. That has nothing to do with that.
Uber
nothing
ruined
to
my
do that with
marriage.
that. So yes,
All
this
right,
this
tell
one
us
is,
about it.
like you said, 2017. A businessman sued Uber for $48 million in 2017. Now here was the problem. He claimed that a flaw in the ride-sharing company's app played a role in breaking up his marriage. So he had borrowed his wife's cell phone, and he used it to log on to the Uber app, again, with wife's cell phone. And when I ended the show last time, the 20 Crazy Lawsuits, I teased this one. So if it sounds familiar, this is the one I referenced, saying that when we do another show, it's going to be on there. But anyway, this guy had his wife's phone, used his wife's Uber app, and he called an Uber. Well, as a result, the app continued to send notifications to his wife's cell phone about his whereabouts whenever he used Uber.
Okay.
So he alleged that it was a glitch in the app that continued to notify his wife even after he had logged off. Because of that, the wife was able to keep up with his movements, and it caused a problem that led to discovering multiple affairs where husband was claiming to be one place, but the Uber app showed he was somewhere completely different. And it led to the end of the marriage. It landed in divorce.
She was following him.
Well, yeah, she had the Uber app. I mean, she couldn't help it.
Yes, good
so
for
the app
her.
is saying, we're picking you up at this
Yep.
location, taking you here. And it turns out it was husband using the Uber app to go and see other women, and the affairs were discovered, and that's what led to the divorce. So he thought, well, fine, I'll sue Uber, and he did for $48 million, but it was thrown out.
I'm going to cheat on my wife, and I'm going to sue Uber because I'm doing something wrong.
Right.
I mean, come
Because
on.
They disclosed it.
I feel like I'm going to say that a lot in this show, but my goodness.
Yeah. So that's
Okay.
number 1.
Okay. Yep.
Uber ruined my marriage.
Uber ruined my marriage. That is truly worthy of being on the show because that is ludicrous.
Yes.
All right. Number 2 on our list, my imported beer came from St. Louis. That's what we've titled this. My imported beer came from St. Louis. This case happened in 2013.
Correct. So some beer drinkers filed a class action lawsuit against Anheuser-Busch seeking more than $5 million. And here's why. They claimed deceptive packaging caused them to believe that the beverage that they were getting was manufactured in Germany. You've heard of Beck's beer. Mm-hmm. Beck's beer is a German beer. Mm-hmm.
Yes.
The label and everything they alleged made them believe that the beer was actually manufactured in Germany. However, the production of Beck's beer was moved to St. Louis, Missouri in 2012. But made in the USA was almost non-existent on the label. So they felt like, under false pretenses, they were believing they were buying an imported beer from Germany, but in reality, it was bottled in St. Louis, Missouri. So the result of this, the court ruled in the plaintiff's favor. So the court found in favor of the people that filed the class action lawsuit, and the U.S. approved a settlement for customers who purchase Beck's beer, Beck's Pilsner, Beck's Dark, Beck's Light, and Beck's Oktoberfest beer from May 1 of 2011 until June 23rd of 2015 when the label was changed. Those that had purchased beer, if they had a receipt, the court granted them up to $50 per household if they had a receipt showing they'd purchased any Beck's beer during that window of time. If they didn't have a receipt but claimed that they had purchased Beck's beer within that window of time, the court gave them $12. So they sued for $5 million.
Wow.
Each person as part of the class got $50 if they had a receipt, or $12 if they didn't have a receipt, because they presumed that Beck's beer, a German beer, was manufactured in Germany. Instead, it was St. Louis.
But it used to be.
Yes.
Just because they moved
They
it.
moved it into didn't change anything about the taste of the beer, how it was brewed, the process. None of that was changed. It's just that on the label, it didn't say made in the USA. So they felt like it was deceptive.
Okay.
And apparently the court agreed, and so they were able
Well, the court didn't agree to $5 million.
No. Well,
so
$50 a person with a receipt.
Possibly get $12.
Yeah, exactly.
Yeah, that's really worth your time. That's just my 2 cents on it. So, okay, that was fabulous. This is number 3 on our list. Derek has titled this, "I'm a fireman, but I am terrified of fire."
Yeah.
I can't wait to hear this one.
Yeah, so this is 2014, all right? A Houston, Texas fireman by the name of Shane Proler. Yeah, he's afraid of fire. Shane doesn't like fire, but he's a fireman. As a result, he was reassigned to an office position so he would not have to come in direct contact with the fires that scared him. So again, he's a fireman and he's afraid of fire. So he's given a desk job just so he doesn't have to come deal with fires. Since he wanted to remain in his former job in the fire suppression unit, or in other words, those that put out the fires, that wasn't good enough for him to sit behind a desk. So he claimed that his fear was a disability and that he was being discriminated against because of his disability. His case made it all the way to the Texas Supreme Court, which ruled there was no evidence that Proler was discriminated against on account of his disability. So yeah, he's a fireman. He's afraid of fire. So they take him off the fire suppression unit, put him on a desk job. So he claims that that was discriminatory, that his disability, being afraid of fires, that they discriminated against him, and he filed suit, and the Texas Supreme Court went all the way up to that level.
But he didn't want to be in front of the fire.
But he didn't want to sit behind a desk. All he basically wanted to do was collect disability, because I'm a fireman, I'm trained to put out fires, but I don't like fires. Okay, well then we're going to put you in a desk job. So they did. And then he filed suit claiming, I want to put out fires, but I can't put out fires because I'm afraid of fires.
Yeah, no.
And this was a lawsuit.
Okay. And do we know the result on this one?
Yeah, the Texas Supreme Court threw it out.
Oh, you read that. Yes.
They
Okay,
ruled
sorry.
there was no evidence that he was being discriminated against
on
account of his disability. Yeah.
Yeah.
You're speechless.
I am absolutely speechless. I'm quite certain if he was put back in the fire suppression unit and said, okay, you're not discriminated against. You go fight fires. You're now on shift.
What's he going to hide in the truck?
Right? That is not who I want to show up at my house to help me, my children, and my pets if there is a fire at my house.
And he's afraid.
Yeah, he's not. He's not coming in. He's not helping. So anyway, more power to him. All right, number 4 on our list. We have this titled, "Drinking beer doesn't make your dreams come true." This is 1993.
Right, as if we all didn't know that the court had to figure this one out for somebody. And the plaintiffs did lose in this one. So in this one, we've all seen many beer commercials over the years. You see all kinds of commercials. Typically, you'll see beaches, you'll see good-looking men, good-looking women, the Clydesdales, all these fun, incredible, wonderful things that surround the beer commercials. Well, although the majority of the population, I think us too, we know that none of that's real. But a guy by the name of Richard Overton believed it was, at least so he claims. So in 1993, he sued Anheuser-Busch for $10,000 for false advertising. He claimed that the beer ad caused him emotional distress, mental injury, and financial loss. Mr. Overton said that the company's ad showed beer's ability to enable, and he quotes this, "scenic tropical settings and beautiful women and men engaged in unrestricted merriment," unquote, when this was actually not the case. So he lost his lawsuit. Yeah, he sued because drinking a beer did not suddenly put him on the beach with a bunch of good-looking men and women or in some scenic, beautiful area. That's...
Oh, my gosh.
Yeah.
Are you serious?
Yes.
Yes, exactly.
Yes. Thank you from the Peanut Gallery. It's unbelievable. Obviously, this man has never taken a marketing class in his life and doesn't know how you actually market products to get people to buy them. Second of all, the fact that he thought this was a lawsuit.
Yeah.
That this was worthy of some sort of compensation.
Now, I don't know this is a fact, but I will say that a lot of these were probably not involving attorneys. You can file suit in some states pro se in state court, meaning you don't have to have an attorney. So as an attorney, I never would have clearly touched this case, but doesn't mean somebody didn't. I don't know whether this one was one that had an attorney or not, but yeah, he sued Anheuser-Busch for $10,000 because drinking that deep beer did not suddenly project him to a beach somewhere with a bunch of fun people.
Wow.
And again, the quote, scenic tropical settings and beautiful men and women engaged in unrestricted merriment.
Next time we're sitting on a beach, maybe our honeymoon, we're going to cheers to Richard Overton and say,
right.
you know what?
Yeah. Yeah.
Our dreams did come true, and
That's
we're
right.
drinking this beer.
And we're drinking
going
and
to
enjoying
enjoy
this
that.
beer.
There
Right.
you go. All right. Number 5 on our list. Again, these are in no particular order. I'm numbering these in case you're doing something and you're just trying to remember which one you want to vote for. Derek has this titled, Michael Jordan is my doppelganger. I can barely get through these without laughing.
If you don't know what the word doppelganger means, it means that you have someone who's a lookalike,
Yes.
exact lookalike of you. Doesn't mean they're a celebrity necessarily, but it means that there's somebody else that looks exactly like you. And supposedly we all have at least one doppelganger walking the face of the earth. Well, for this guy, this was back in 2006. The lawsuit was dropped, so it never made it to court. Many people would be happy if they looked like a celebrity unless the celebrity was as famous and loved as Michael Jordan, apparently. Now, in 2006, like I said, a guy by the name of Alan Ray Heckard from Portland, Oregon, sued Michael Jordan, the basketball legend, Nike promoting Michael Jordan, for more than $800 million.
That's what he was asking for?
$800 million.
Oh, my gosh.
So his claim was that he had been confused for Michael Jordan every day for the last 15 years. People confused him as being Michael Jordan, and that because of that, it's caused him permanent injury and emotional pain and suffering.
He should have just capitalized on it.
Well, yeah, autograph sessions or
Right.
celebrity lookalike, birthday parties.
That is a career in Vegas,
Yes,
right?
yes.
Or Atlantic City or anywhere. You can
learn how to shoot a basketball, dribble a basketball, and hey,
Wow.
you can
Yeah.
dress up as Michael Jordan and make some money off of it. Instead, he sued Michael Jordan for $800 million because he looked like him.
I really want to see what he looks like.
Well, I know, I do too.
know.
You got to Google the name.
Alan Ray
Heckard.
Heckard.
Are you kidding me?
Heckard.
Yeah.
Alan Ray Heckard. So he
All
must
right.
look
Michael
a
Jordan's
lot
my
like Jordan.
doppelganger. 800 million. Wow. All right, number 6. Where's my chicken sandwich? This is recent. This was 2019.
Yeah, and this one is still pending. This one
okay.
it would probably have gone to trial by now, except for the fact COVID's had courts shut down
All
just
right.
about everywhere.
Well, we're going to have to follow this one.
And you'll probably recognize the story as I get into it. So this came from Tennessee. A Tennessee man sued the fast food chain Popeyes Louisiana Chicken. You remember when they came out with their chicken sandwich?
Yes, all the
Yeah,
craze,
everybody
right?
ran out. There were fights in drive-thrus. There were car wrecks in drive-thrus. There were lines around the corner, not buying gas, but apparently wanting to buy a chicken sandwich from Popeyes.
Yeah.
So this guy sued Popeyes for $5,000 for running out of its famous chicken sandwich because here was his claim. He claimed that the restaurant wasted his time trying to fill his order. So the guy's name was Craig Barr, B-A-R-R. He said that the company deceptively advertised the sandwich, which was only available for a limited time in August. This was the initial launch of this, just for August of 2019. So Barr is also suing for damages to his car and said that it occurred while he was in the parking lot of the Popeyes. So the case is scheduled to go to trial sometime soon, maybe January of 2022 is when the courts are potentially going to open back up again. So he sued Popeyes because they ran out of the chicken sandwich
I mean,
for $5,000.
what happened to his car?
I don't know. Didn't say.
Probably ran out of gas.
Yeah, exactly.
I don't know. That was mean.
Yeah.
Oh, okay. Well, Craig, good luck to you. If that chicken sandwich was worth $5,000, I mean, wouldn't that be court fees? And isn't that about how much it costs anyways?
They're called crazy lawsuits for a reason.
That's right.
Don't forget.
You're exactly right. Okay. Oh, here we are. Number 7. You have this titled, Give Me Your Cell Phone. This is also relatively recent, a 2017 lawsuit.
So this one would not occur in the U.S. If it did, I'd be shocked. But this one came from Spain, and I think every parent knows about this kind of situation. So a 15-year-old boy, 15-year-old boy in Spain sued his mother, his mom. He claimed that he was mistreated after she took his cell phone to try and get him to study.
Wow.
To study. He's 15 years old. Mom took his cell phone. So he sued, claiming that she mistreated him because she wanted him to study.
Okay.
He also sought jail time for his mom and,
no.
and reimbursement for his legal expenses. A judge clearly ruled in favor of mom, saying that she was within her rights and acted responsibly to get her son to crack the books and study.
Oh, my gosh.
Yeah.
Say what?
Yeah, that an appropriate sound effect there. So
wow.
15-year-old. Yeah. Give me
Okay.
your cell phone. Instead, he sues mom, claiming that he mistreated or she mistreated him, and asked for jail
I
time.
wonder what their relationship is like.
Yeah, I don't know if
I bet he's
living
a
at home.
handful.
Right, exactly.
Jeez.
2017, so he was 15. He's on his own now.
Yeah, or not.
Well,
Maybe
true.
he didn't study and he still lives with mom. I don't know.
Yep.
All right. Number 8, a shocking case of trespassing. This was 2002.
Correct.
Okay.
And this one, the plaintiff does win. So I'm going to go through the facts.
All right. You gave us the end.
Right,
All
exactly.
right.
So listen to the facts, and then we'll talk about the win. So this one is proof that you can win a lawsuit if you're injured while trespassing on somebody else's property. So listen to the facts.
Okay.
Lancaster, Pennsylvania. There were 2 teens that were severely burned while on top of a parked railroad car. They were skateboarding, Jeffrey Klein and Brett Birdwell. They illegally entered a properly owned Amtrak Norfolk Southern scrapyard or a parking lot area for the train cars, and they climbed on top of a boxcar in hopes of getting the view of the city.
Okay.
Again, this is Lancaster, Pennsylvania.
See 2 teenagers doing that.
Sure, an uninsulated wire suspended above the train jolted Klein with 12,500 volts of electricity, causing burns over 75% of his body. Birdwell received burns over 12% of his body. Both of them, their clothes were on fire,
Oh,
so
my
pretty significant
gosh.
shock. So in October of 2006, the trial occurred. Again, this happened in 2002. Went to trial in 2006. A jury said that although they were trespassing, the 17-year-old boys bore no responsibility for the accident. None. Instead, the blame fell entirely on Amtrak and Norfolk Southern for failing to post signs warning of the danger from the electrified wires that power locomotives. So for medical costs, pain and suffering, and loss of life pleasures, the teens received a combined $24.2 million.
Wow.
Now, I'll give you a little background on this.
Okay.
This is off the point. But in Georgia, and many other states have this, there's a law called attractive nuisance. We covered this.
We have covered it.
In a prior podcast.
Yes.
But generally, it's for a younger, much younger child. Now, granted, they're 17 years old, so they're still considered to be minors. They're not 18. And the attractive nuisance doctrine means that if you do have something that is potentially hazardous, you have to build a fence or somehow, some way prevent specifically children because they can get injured. Think about a pool. A swimming
That's
pool.
exactly what was about to
You build
I
a
was
fence
thinking.
because you're required by law to do that. But it's also, too, to prevent young children from the neighbor's house or down the street falling into your pool and drowning. So the attractive nuisance doctrine requires that you protect others that may be trespassers. But I would have argued, and I'm sure that the defense attorney did, that these kids are 17. They have a little bit more knowledge than a 10-year-old or a 5-year-old. But yet they climbed on top of the boxcar, were shocked and severely injured, and wound up with a $24.2 million verdict.
I'm thinking of this. Even if that jury, when they go to trial, they're going to have those medical bills. I mean, what if this is just maybe they're not liable, but Amtrak's got deep pockets. Let's give these 2 boys some compensation to help them for the rest of their life.
Sure, and that's probably the motivation.
Right. This is the
perception.
reason we can point the finger. Not even kind of. We can give them compensation.
Sure.
Get all their medical bills paid, and I mean the one that was burned, he was on fire.
Yes.
I mean, what's his quality of life? I don't know. Obviously, it's the first I'm hearing of it.
75% of his body. That's significant.
Exactly. I mean, we don't know if he's facially burned for the rest of his life. I mean, who knows? But I don't know. I mean, it's crazy in the situation that happened.
Right.
That they were trespassing because in reality, they truly were at fault. They were somewhere they should not have been.
Correct. They could have been arrested for being in there if they had not been injured.
But they were injured, so now it makes it Amtrak's fault.
Correct. And that's the reason why this one made the cut.
It does. It does. I can see it both ways. I can see as a company giving these kids some money for their bills and things, but then I can also see shouldn't have been there.
Right.
You
You
shouldn't
broke
have
the
been,
law.
You snuck in.
Uh-huh.
Yeah. All right. Well, let's keep going. I just like to talk
No,
it out.
no.
It's very interesting to me. All right. Number 9. This is titled, Who Wears the Pants Here?
All right. This one's 2007.
Okay.
The plaintiff in this one was actually a judge. This is a judge that filed this lawsuit. Okay. Keep that in mind.
Okay.
So a court ruled against the dissatisfied customer, again, also a judge, of a Washington, D.C. dry cleaner. He sued the dry cleaner for, and this was the dollar amount he put in his lawsuit, $54 million for allegedly misplacing his pants. One pair of pants was lost, and he sued for $54 million. And ordered, when he lost, he was ordered to pay the company's legal fees, as he should have. But the customer, an administrative law judge by the name of Roy Pearson, could not prove that the store had lost his pants. His suit was based on the claim that the store's sign out front said "Satisfaction Guaranteed." So that was the basis of his lawsuit. The case drew national attention. I remember seeing this, as well as sympathy for the defendants who received funds online for their defense. They had to pay an attorney to defend this. But a judge sued them for $54 million, claiming that the Satisfaction Guaranteed sign meant that they had to provide best quality service. And since apparently his pants were lost, he thought $54 million
that's really
was an
sad.
appropriate
And
amount.
he's a judge.
And he's a judge.
Come on.
Yeah.
Even
Are
$1
you kidding
million
me?
would be extensive.
Right.
Yeah.
The pair of pants was probably, maybe a tailored pair of pants, $150
Right.
at the most. But yeah.
Are we having a little technical difficulties back there?
Sorry. I'm just
An abundance of sound effects.
having fun listening to all of these.
I know, right? All right. Number 10, The Sleepy High School Kid, 2008.
Yes. So this case was dismissed. This was, again, 2008. Parents of a Danbury High School student. His last name was Robichar. We'll go with that. Let's just say Vinny. Said that their son suffered hearing loss after one of his teachers slammed her hand on his desk to wake him up during math class.
Goodness.
The family sued the school board, and the city, but the case apparently fell on deaf ears.
Uh-huh.
Yeah. So the case was dismissed, but because the teacher woke him up, she apparently slammed her hand on the desk to wake him up. They claimed hearing loss, and they sued everybody. But
Nice.
the case was thrown out.
Okay, good.
He fell asleep.
Yeah.
Again, the parents weren't apparently upset about the kid falling asleep.
Yeah.
So-
It's the teacher. Somebody else's fault, right? All right.
Exactly.
Number 11, I want my money back.
All right. So this one, see what you think about this one. I'm
Okay.
just going to read the facts and we'll go from there. So for many Americans, joblessness, it's one of those unfortunate things that happens when the economy goes bad. People can't find jobs. People lose jobs. There are all kinds of reasons. But this girl named Trina Thompson of New York was unable to find a job following her graduation from Monroe College. She filed a $72,000 lawsuit against the college in 2009. She graduated with a 2.7 GPA. 2.7. So she's not among the top of her graduating class.
Right.
And she claimed that her college career services department didn't provide sufficient help with her job search and gave preferential treatment to students with excellent grades.
Really?
So she had a 2.7. She's ticked off because those with a 4.0 or maybe 3.5, whatever, were given preferential treatment. So she sought to regain $70,000 she had spent on tuition for her bachelor's degree in information technology, plus an extra $2,000 for the stress caused during her 3-month job search. She searched for a job for 3 months.
Right. Out of college.
Out of college. And it's the college's fault.
And probably thinks she should make $72,000.
Yeah, and
Right
she
out of
has
college.
a 2.7 GPA.
Well, she's got issues. Sorry, Trina.
Yep.
All right. Number 12. Want you hold my hairy hand? Am I reading that right?
Well,
want you hold my hairy hand?
yes.
Does that mean won't?
Yes.
Oh.
Well,
These are crazy.
I left off the word I. I want you to hold.
I
my
want.
hairy-
Okay, so it's
That's
either
a
way.
typographical error on my part.
Sorry about that.
I want you to hold my hairy hand.
Okay.
All right, so listen to this one. So this is a young man named George. He had an ugly scar on his hand, and so he went to a surgeon to try and figure out what could be done to eliminate the scar. pretty bad scar. So the surgeon said, okay, we can fix that. And he grafted skin from George's chest to cover the scar on his hand. Well, George has a hairy chest. So
oh my goodness, I know what you're about
George's
to say.
skin graft from his chest
now
creates a hairy hand. So George now has a hairy hand because of the skin graft from his chest.
Oh,
so George sued
George.
the surgeon and was awarded the difference in value between a 100% good hand and a hairy hand.
What would that value be?
It didn't say the dollar amount. So I'm curious. I want to know too. So George now has one hairy hand and apparently one hand that's not hairy because they took the skin graft from his chest.
Oh my gosh.
So that's why it was saying, I want you to hold my hairy hand.
Well, that definitely makes the list of crazy lawsuits. But do you think that's something they would have thought about before they did a graft from your chest?
You could shave the hand. You could hair removal.
Oh, God. I gotta moving on. Oh. All right. This one is called Bubbles in the Fountain.
Yes. So July 7th of 2001, somebody thought it would be a pretty good prank to dump detergent in Canal Park's fountain in Duluth, Minnesota. So it created a mountain of bubbles, as you can imagine. Again, this was early morning, July 7, 2001. So several hours later, a passerby by the name of Kathy Kelly walked into the suds that were coming out of the fountain, and she slipped. She sustained a laceration to her left lower shin. Due to her diabetes, the cut later became infected, resulted in $43,000 in medical expenses.
That, you want to talk about wrong place, wrong time.
Right.
Poor thing.
But she slipped in the suds that were coming out of the fountain. So she sued the city because it had not cleaned up the suds or posted warning signs, despite the fact that municipal workers had received a call concerning the hazard some 4 hours earlier. So she's saying they knew about it. They had noticed 4 hours before. They hadn't put signs out. They hadn't cleaned it up. So in March of 2004, a jury found that the city was 70% responsible for her injuries and that Kelly was 30% responsible, and they awarded her $125,000.
Okay.
And now the fountain, that same fountain, has some railing encircling it.
Covered her medical expenses.
Yeah.
So they can do that, the percentages?
Remember, we've talked about this in prior podcasts before as well. It's called comparative contributory negligence, where a jury gets to assess a percentage of blame against everybody involved. So if your percentage of fault is 50% or more, you get nothing in a pure comparative contributory negligence state. But if your negligence like this was 30% on Kelly, her award was reduced by 30% to account for her percentage of negligence. Okay. So when you applied the 70%, apparently it came out to be $125,000 that the city had to pay.
Sure. Okay. No, I do remember that. All right, we're on 14, and I'm just trying to get through these because I want to get to 20, so we can definitely do the voting. This one, it says Wendy's finger, and I know this story. So
I think everybody does.
Is this the one we all know from the news?
Yes.
Okay.
So I'll quickly go through it.
Yes.
Right. In March of 2005, a lady by the name of Anna Ayala filed a claim against Wendy's franchise owner in San Jose, California. She claimed that she ordered a bowl of chili and she found a fingertip in the bowl of chili. The bad publicity cost the fast food chain about $21 million in lost sales and cut businesses at some Northern California locations by as much as 50%. So $21 million loss in revenue. Business dropped by 50% at all Wendy's chains. But authorities found no evidence of missing fingers at the accused restaurant or anywhere along Wendy's supply chain. Suspicion grew against Ayala, and she eventually was arrested and found guilty of attempting to extort money from Wendy's. She had served 4 years of a 9-year sentence as a condition of her probation. She was banned from ever returning to a Wendy's restaurant. But they did find that apparently it was traced to a guy by the name of Brian Rossiter, a co-worker of Ayala's husband. He lost the tip of his finger in a work accident, and he owed the couple $100. So instead of giving $100, he gave them the tip of his finger she then used to drop in the cup of chili at Wendy's to claim that it was in her cup to be able to sue Wendy's.
Oh, my gosh. Do you know, I have a Wendy's right near my office, and I eat that chili a lot. It's one of my favorite lunches is a baked potato. And I have never, ever eaten that chili without thinking about this story.
Well,
Because we heard it.
But now we know the rest of the
I didn't
story.
know the rest of it. I didn't know it was all fake. I just, I had heard on the news, Wendy's found a finger in the chili. And the chili is phenomenal, by the way, if you've never eaten it. But I just, I hate that story. But I'm glad to know it was all fake. It was all planted,
right.
And she was arrested
But she had sued based on that, right?
Because think of the lost sales. If all I heard was the top of that story all these years ago from 2005, it probably hinders people from ordering it.
Yes.
Just the way it doesn't hinder me, but I still think about it.
Mm-hmm.
So anyway, good for them. Not for Anna for doing this, for Wendy's for realizing that it was fake.
Yes.
So, okay, number 15 on our list, the 4x4 lumber or something close to that.
All right. So one or more recent court cases, a group of Chicago plaintiffs filed, again, a class action lawsuit against Home Depot. This was back in 2017. They claimed that the 4x4 lumber that they were selling was actually only 3.5 inches by 3.5 inches on each side. So Home Depot and other lumber suppliers explained that a 4x4 is just the name of the boards, that the industry standard dimension is really 3.5 by 3.5. Nevertheless, the plaintiffs were suing for $5 million in damages. So on March 12th of 2018, a U.S. district judge rejected the plaintiff's claim and dismissed the case against Home Depot. It means the plaintiffs are free to refile at any point if they choose to. It was dismissed without prejudice. But yeah, they filed suit because a 4x4 board lumber was actually 3.5 by 3.5.
Wow. I mean, that is kind of a big deal. If
Remember
you're
we talked about
something.
The foot-long subs were only about 11.5 inches at Subway. This is kind of like that.
Was that in the first? Was that in the
was
top
the first
20?
one.
Okay.
Yeah, that was the first 20.
Okay, so that was number 15, 4x4 lumber or something close to that.
Yeah.
And I've been in construction long enough, 20 years as a designer, 21 years now, and you can't make mistakes like that. You can't have lumber that's not exact. So,
well, did you know that the industry standard is considered to be 3.5 by 3.5?
Yes.
I didn't.
That
know.
I did
know
know.
that.
Yes.
Apparently, this group in the class action lawsuit didn't know that either.
Well.
So there you go.
Anyway. All right. So I had promised we were going to get to 20, but for the sake of time, we never have enough time. We could go,
it flies.
you
It flies.
work on the show and pull all this up. But we definitely have one more that we want to get to because we feel like we're going to get to 16. So we're going to vote on 16. But this last one that we're going to reference is top 16 worthy. And we'll just mention the next four, the four that we didn't get to. So we're going to vote after this. So we want to say the last case, and then we're going to tell everybody how to find you and where they can submit their votes. Okay? All right. So number 16 on our list, Derek, you have this titled, Can Someone Make Me a Sandwich? Or Does Tesla Make a Motorhome?
I gave it 2 titles because I thought
can't
it was
wait to
worthy
hear
of 2
this one.
titles.
Okay.
So I don't know the year on this. I tried to find it, but I couldn't. My assumption is it was roughly around the time the technology was developed for cruise control. So you may know where this is going. So a woman purchased a 32-foot Winnebago motorhome from a dealership in Oklahoma.
Mm-hmm.
So on the way home from a football game, I'm sure they'd gone and tailgated and stayed in the motorhome. She drove on the freeway, and she set the cruise control. So then she left her seat to go make herself a sandwich.
No.
Needless to say, the motorhome veered off the freeway and crashed. So the lady sued Winnebago for the owner's manual that the person actually doesn't say, not writing in the owner's manual, that a person can't actually leave the driver's seat while the cruise control is on. And a jury in Oklahoma awarded her, get this, $1,750,000 plus they awarded her a brand new motor home. So as a result of that, Winnebago updated their owner's manual to say that if you put it on cruise control, it doesn't mean you can get up and leave the driver's seat.
Shame on that jury. That's all I have to say. That's my opinion. But come on.
She got up to go make a sandwich.
Who did she think was going to steer?
Well, that's why I say, does Tesla make a motor home? That was why it was the second title to this.
Oh, my goodness.
Yes, she, I guess, assumed that cruise control meant that she could just set it and get up and go.
I guess. And the
And a
people
sandwich was more
hearing
important.
this in the courtroom sided with her.
Yeah.
And I think it's lunacy, but I don't know.
But you think about now all the warning labels that come on things.
Yeah, and they're for her.
Right.
And people like
people
her,
like her,
obviously.
exactly.
Right.
Exactly.
There's a little bit, not even a little, a whole lot of common sense in there.
$1.75 million.
Wow. Okay. Well, that was our top 16 of the craziest lawsuits, part 2. If you love this show, go back and listen to part 1. I urge you. It is equally as entertaining. But all your shows are entertaining, Derek, and very informative. I know I say it on every show almost that I feel like I'm getting a secondhand law degree just by listening to all your education.
And this one, it's what not to do.
Exactly. All right. So everyone listening, tell them how to find you if they have a legal question, if they've been injured, would like to talk to you about representation, or if they would like to submit a vote.
All right. I do want to give all the ways to find me, but give me real quick, what's your top number 1? You, Lita. And Mike, that goes to you as well, and Amanda also, if you can give me.
I'm all the way back at number 1. That Uber ruined my marriage.
Okay. Well, I heard Amanda say that Wendy's, the tip of the finger in the chili, got her vote. Mike, how about you?
I like the first one only because I like seeing guys like that get their comeuppance. The one that used Uber and got caught cheating.
Well, yes, I agree with that as well. But I also, too, like poor George, the hairy hand, who now had to file suit.
Yes.
I just a visual of a guy with one hairy hand and one not. But anyway, that and also the Winnebago. All right, well, go on my website. It's Law Office of Derek M. Hayes. The website is derekmhayes.com. It's DEREK, the letter M, Hayes, HAYS, derekmhayes.com. There you can find the podcast tab. You can submit a question. You can also submit a question directly to me. You can also go to my Facebook page, Law Office of Derek M. Hayes. Find me there. Or the Facebook page for Injury Insider with Derek Hayes. Also on Instagram, Derek M. Hayes. You can find me there or call me. My office number is 404-777-HURT or 678-225-0970. As always, the initial consultation is free. I'll be happy to talk to you about your case, but please go online this week and vote.
All right. Thank you very much for joining us on Injury Insider with Derek Hayes, presented by Status Home Design and the Law Office of Derek M. Hayes. Don't forget that you can enjoy any of our episodes anytime by visiting businessradiox.com, selecting the Gwinnett Studio, and then clicking Injury Insider with Derek Hayes. This program is also available on your favorite podcast app. Until next time, for Derek Hayes, I'm Lita Brooks, and you've been listening to Injury Insider on Business Radio X.